Hello, showtime, showtime. How are you? Happy Labor Day. If you are celebrating Labor Day, say hi in the comment. What are you doing? What have you been up to this weekend? We got great news to share with you. Just waiting for you to get in so we can get started. Hello, say hi in the comments. How are you? How have you been? We got great news to share with you. We got 5 people. Hello, how are you? Let's get right into Hi Grace Dime. How are you? Where are you located? Happy Labor's Day. If you're celebrating, let me know what are you doing. Are you drinking? Are you partying? Hi Gonzalez. Thanks for coming back. We're gonna talk about this great news. Oh, you watch later. Okay, Charles Amos, how are you? Music TV from Utah. Long time. How are you? How are you? Yes, we got 10 people. Oh my gosh, we got a lot of people. We're gonna talk about this case. Oh, you traveling? Safe trip. Have a safe trip, Charles Amos. Have a safe trip. Oh, Grace Dami watching from Maryland. That's great. Well, I'm here in Maryland. If you ever need a lawyer, let me know in the comment. Hi, Rakesh. I'm doing good. Feed gone. Magni from New York City. How are you? All of you guys, please go ahead and like right away. Please go ahead and like right away. And please go ahead and share. We're going to talk about a great news, administrative closure. Remember, this all week we're going to be talking about removal defense. What can you possibly do when you are in removal? We have a lot of subjects to cover during this week, 6 p.m. Eastern Time until Friday. But today we're going to focus on administrative closure and motion to terminate removal. I'm going to share with you good news because we had a judge on August 29, okay? Uh, Pretty much granted us administrative closure based on humanitarian reasons. We didn't have anything substantial, but we just argued humanitarian reasons, and he granted us administrative closure, which is good for our client because now he's just going to have to wait for the child to turn 21, petition for him, or if the wife wins asylum, then they can get all the thing together. But anyway, this is a great story I'm going to share with you. Pierre, how are you? I'm doing great. Nice to see you from Florida. I used to live in Florida, Pierre, in Jacksonville, Florida, back in the days. Are you still in Florida with this governor? Oh my gosh, that guy is crazy. How are you holding up? Any good news for non-immigration people, my friend? For non-immigration people. Well, what do you mean? We only talk about immigration here, right? So I don't know what news you need about the bill. Oh, yeah, I haven't heard anything. But you know what, Rakesh, you just have to wait for next year because next year it's election day, election year. So you gotta have to wait for next year so we can talk about it. I think next year because everybody is trying to, win the general election. So every president will come up with something. I think we will hear more about it next year. So yeah, we got only 4 months left. And next year, everybody's going to come up with their plan. So we have a sense of where we stand next year, okay? Salut, Bijoux. Hi, salut. How are you? Wilbur Valestil. All of you, please go ahead and like. Please go ahead and like so I can share my screen, okay? Please go ahead and like and share. So I'm going to share my screen. I'm going to talk about removal defense. If you don't have anything to argue, you have a weak case, and you have children that are younger, I strongly suggest you just go with administrative closure. It's easy to be granted, okay? So let me share with you so you can buy some time and stuff like that. Let me just share my screen with you so we can get started. I'm glad you guys are. We got a lot of people today. Please go ahead and like, okay? Since we got a lot of people, please go ahead and like. Oh, Valesti watching from New York. Hello, New York. I was in New York in May, actually. Yeah, I love New York. I like to go to New York sometimes. I might go to New York again in October. Yeah, so let me share my screen so we can talk about it. Magnifogo. Okay, let me share my screen. Okay, I'm gonna tell you about what's going on with this the story. So I put my screen bigger so you can see, right? So I hope you can see. Anyway, the client into the United States in 2004. Okay, 2004. How long it has been? It has been almost 2004 to 2023. Well, let me see how long it has been. I don't know how to calculate. Okay, let me see. 2020, 23. Okay. 20, 20. Okay, let's see how long it has been. 2004, 2023 and 2004. Let me calculate quickly. Oh my gosh, I can't even do simple math. Okay, hold on. Let me calculate. 2023, 2004. Okay. 19 years, right? It's been 19 years. Okay. So the client entered in the United States in 2004 as a crew member. That's C1 visa, bad type of visa. Okay. As a crew member, it's really bad because it's challenging to adjust status later on. Okay. So client, unless you win asylum, of course. So client entered in the United States in 2004 as a crew member, okay? Then in 2015, almost more than 10 years later, okay? 11 years later, he applied for asylum before USCIS. Well, but unfortunately, the asylum was referred to court because first of all, you apply late and you don't have a strong as valid reason as to why you apply late. Not to mention the asylum in question is not really strong as a claim, okay? Then what happened, the asylum office referred his case to the immigration court in 2017, okay? So, and then in 2018, his wife, in 2018, he used to have another lawyer. The lawyer applied for cancellation of removal. But remember that if you enter as a crew member, it's really hard for the court to grant cancellation of removal. And then in 2019, his wife applies for asylum. Okay, the wife asylum application is still pending with USCIS. So, and then the client's children have a chronic disease, some type of serious disease. Okay, so and then because the client entered the United States, which we call respondent in court, right? But anyway, the client entered the United States with a C1 visa, the court will not grant asylum. So that's why we had to apply for administrative closure. Let me show you, first of all, why we had to apply for administrative closure. Okay. Hold on. Cancellation of removal. 42B. 42B, if you look at it, the requirement for 42B, okay? If you just go to the application itself, I'm pretty sure you can see, right? Okay, if you go to the application itself, it says some people are not eligible for cancellation of removal. Okay, you're not eligible for cancellation of removal if you enter the United States as a crew member. Crewman after June 30th, 1964, you are not eligible for cancellation of removal. You can argue all you want, you are not eligible. J1 visa, not eligible. Even this one, regardless of either you have fulfilled the 2 years residence requirement or not, you are not the J1 visa. You're not eligible for cancellation of removal. Okay. And even if were admitted and later on became a J1 holder, you are not eligible. If you are inadmissible under section 212A3, those are certain crimes, you are not eligible either. Okay. If you order, incited, assisted, or participated in persecution, you are not eligible. If you were previously granted relief and for some other things, you are not eligible. So I want to focus on this one, right? So if you entered as a crew member after June 30th, 1964, you are not eligible for cancellation of a removal. You can go all the way to BIA. People have done it and they were still not eligible for cancellation of removal. Okay, that is the reason why we went with administrative closure, because we didn't have any strong case. We did not have any strong case as far as asylum was concerned, as far as cancellation of removal was concerned. We just asked the judge to terminate removal, but he did not agree with us. He actually granted administrative closure based on humanitarian reasons. The reason we were arguing, talking about, well, this person's wife has asylum still pending with USCIS. On top of it, they have children with chronic diseases, US children with chronic diseases. And on top of it, we try prosecutorial discretion, and we never receive any response. And this is happening here in Baltimore, by the way. So this case is from Baltimore. And because the case was pending, it took, as I always say, if the case is still open and pending, it only takes 13 days to get a response. So we filed and we got the response within 13 days. The judge granted administrative closure. Why is it good? It's good because at this point, they don't have to be worrying about being removed. They'll keep the work permit and they will continue to wait for the wife asylum to be adjudicated with USCIS. Okay? And the children will turn 21. Can they adjust status later? They can try by trying to argue extreme hardship, right? With a waiver and hope it gets granted. But with children, with spouses, I've seen it before, but with children, I don't think so. But the good news is if the wife gets cancellation of removal, later on she'll get a green card, then she can petition for the husband. Or if she wins asylum, then everybody's problems is solved. But at least the case is administrative closed. He can keep the work permit, no worries for deportation at this point. Okay, so that's the best we could have we came up with, because it's better than having the order of removal. Trust me, it's really better, because if you've been order removed, you're so stressed out. Okay, so now the question becomes, how do I get them to agree with me with administrative closure? Okay, this is the matter of Avetisyan. This is the case that has the standard for administrative closure. Okay, so this is how they go with it. Okay, in determining whether administrative closure of proceeding is appropriate, an immigration judge or the Board of Immigration Appeals, of course, should weigh all relevant factors, including but not limited to the reason administrative closure is sought. What is the reason you're asking for administrative closure? The basis for any opposition to administrative closure. Why those people cannot oppose it? Why the opposing counsel cannot oppose it? Okay. The likelihood that the respondent will succeed in any petition or application he or she's pursuing outside of removal. That's what we try to tell them. We try to tell them that, look, this person has a wife who has an asylum pending case with USCIS, and this person is a beneficiary of this asylum. If this asylum get adjudicated, he might get the asylee status, okay? Furthermore, this person has children who have some type of chronic diseases and they're US citizen. So for humanitarian reasons, okay, why, you see, the reason administrative closure is sought. For humanitarian reasons, if you can allow him to work until the child turn 21, then they will be old enough to actually work and support themselves because they're US citizen, okay? Number 4, the anticipated direction of the closure. We didn't tell them the anticipated duration. We just told them that until the wife petition get adjudicated, okay? The responsibility of either party in contributing in any current or anticipated delay. Well, we told them that we tried to ask OPLA, which is ICE, for prosecutorial discretion, but they never responded to us. So, and then the individual hearing was coming up. We can't just wait. That's why we went directly to court. That's what I always tell people. Okay, if you have a motion to reopen and you try to join ICE and ICE is not trying to join you, my friend, you can just try with the court directly, sua ponte, even if the case is closed. You can try that, okay, instead of waiting for ICE until when they're gonna want to do it, you know. The ultimate outcome of removal proceeding, we talked to them about it, that is going to basically, for humanitarian reason, really, you have to give that to us because look at those children. And the judge agrees with us and they gave us this administrative closure. If ICE want to basically appeal, they have until September 28th to appeal, but they're not going to do it because, you know, it's just administrative closure. And based on the memo that is floating around, this case is not priority. You see, those are the reasons they're not going to appeal, in my opinion. And then if you want to do motion to terminate, this is the standard matter of Coronado Acedo responded. We tried that, didn't work. That's why they gave us administrative closure. And I believe the reason didn't work is because we didn't have a solid petition approved. We just had the wife basically asylum pending with USCIS, hasn't been approved yet. And because of the children, so they're still young. We didn't have any I-130, so that's why the judge couldn't terminate removal. But anyway, if you meet the standard in Coronado Acevedo, then you can try terminating the pretty much the removal proceedings. Okay, and the standard here is pretty straightforward, right? If the judge, let me go back. Let me just go to the standard. The standard clearly says that, you can go read it later, but the standard clearly says that if you have something that has to do with the court, right? So basically, let me see what they say. Okay. The decision can be read to preclude termination in some situation where adjudicators previously have terminated cases, such as where a non-citizen has obtained lawful permanent residence after being placed in removal. Because, yeah. So if you have something, basically what it's saying, if you have something I-130 approved or pending with USCIS, you can ask them to terminate removal, and the judge has the power to do that. Previously, the judge couldn't do it, but this matter came and overturned the previous matter, okay? It overturned the matter of SOG, because in Ohio, they used to really not do that. But now that Coronado has overturned this matter of SOG and FDB, now we can do it, okay? So pending the outcome of the rule-making process, immigration judge and the Board of Immigration Appeal may consider, okay, and where appropriate, grant termination or dismissal of removal in certain type of limited circumstances such as where a non-citizen has obtained lawful permanent residency after being placed in removal, where the pendency of removal proceeding causes adverse immigration consequences for respondent who must travel abroad, okay, to obtain a visa. This is when, for example, you have a lawful permanent resident application that was approved, right? Sorry, you have an I-130 and your spouse is a lawful permanent resident, okay? I-130 is approved. Remember, if it's the spouse is lawful permanent resident, you have to file for a waiver, I-601A, and go out. So, but then if you find yourself in removal, then you can convince the judge based on this matter to terminate removal so that you can travel abroad to obtain your visa, you see? Or where termination is necessary for the respondent to be eligible to seek immigration relief before USCIS. So when you have I-130 and then USCIS lacks the jurisdiction, then they have to terminate your removal so you can go back to USCIS. So that's when you use the matter of Coronado Acevedo. Okay. So this is it. But now I'm going to take questions. Let me go back to the questions. Stop sharing. Questions. Anybody has a question? Okay. Yeah. Let's see the questions. Anybody has a question? Let me see the question. Oh, from Texas. How are you, Arvin? Did you like this video? Sour Music TV, you don't have luck. Well, isn't it your case is depending with BIA? Last time I was talking about how somebody can expedite the case with BIA, Sour Music. You need to watch my video. Okay. 19. When I was trying to make the calculation, yes, 19 years. Okay, I got it later. Okay. So yes, thank you, Gonzalez, for reminding people they need to like and share. Okay, so let's take this question. Okay, Rakish says some people got CO9, people work permit for 2 years. When last year, some immigration visa, so after 20 months, continue that are not. I don't understand. Is it a question or just a statement, Rakish? I mean, if this news is for people who do not have I-485. Okay, someone until 1999 with a U.S. citizen passport, he married a citizen, apply for adjustment status, and get denied. What should be done? Get a green card. Well, Wilbert Valesti, enter with a fraudulent document, you have to apply for a waiver. Yeah, waiver of basically fraud, right? Because you use a false document. The person used the false document. Okay, that's number one. Number two, the person has to adjust under the matter of quilantan because the way they enter is by wave through. They were actually inspected, but with a fraudulent document. There's two things going on. Valestil. Yeah, Valestil, you need a consultation, my friend. There's two things going on. Fraud and entry that can be argued under the matter of quilantan, okay, wave through because they enter with a fraudulent passport. Let me put the consultation link for this guy because yeah, they need a consultation. This is serious matter. You can't just go like that. There's two things involved. One, a waiver of fraud because it's a fraudulent document, and then an argument about the under the matter of quilantan. Let me put the consultation link. Yeah, I put the consultation link here for Valestil. Valestil, I just put your consultation link. You need to consult for that person who into 1999. Administrative closure, we just explained to it right away. Okay. Yeah, we were 4 or 5. Now we're getting people because of the subject, I guess. My Eva C host, yes, that's a valid reason, but it's just up to them to agree with you. But it's a valid reason to expedite based on that. But you have to show proof as well. And making an expedite request, especially if you're making with USCIS, is free. So you're not losing anything. You should do it. Check my question. Yeah, I already answered you. There's two things involved. Okay, the person entered with fraudulent Wilbert. The person entered with fraudulent document. They need a waiver of fraud, and because it's a fraudulent document, it's not really theirs. They have to make an argument for the way they enter. Matter of Quilanta. I already put a consultation link for that person to actually consult because it's not. It is serious. So administrative closure is for people in removal. That's the reason we were actually explaining here, right? Pretty, you need to call them. Why would you, if the green card was approved, why do you need another biometric? You need to call them to find out what's going on. And July 26th, August, September, October, 90 days hasn't passed yet either way. Why they say waiver is not available for that type of fraud? Did the person claim that they are U.S. citizen? They did not. If they claim they're U.S. citizen in the document somewhere in the paperwork, then the answer is yes. There's no waiver for falsely claiming U.S. citizen. But if the person into the United States with a fraudulent document, they can have a waiver of fraud. But if they claim that they are a U.S. citizen under the employment application, under somewhere, they say, oh, yes, I'm a U.S. citizen, then there's no waiver for that. So administrative closure is the person who's in removal. Yeah. Wilbur Valesti, what you have to do is forward my consultation link to that person, okay? That's what you really have to do. Okay, Lindsay Door, hello, Bijoux. After you don't need to wait for anything. Lindsay Door, just if you have a valid reason for expedited request, just make it. You don't have to wait. Lindsay Door, you don't need to wait because making an expedited request is free. Why do you have to wait? If you have valid reason, just put your expedited request with proof. That's it. Okay, don't wait. She got 76. I don't know if it's going to be postponed again. It's just up to the court. But if you want them to do it sooner, you can file a motion to advance, but you have to have a good reason. If not, you're just going to wait for the court to do whatever they want to do. So there's no way of telling. Okay, thanks. Yes, there's a fee for consultation, Wilbur. 175, okay? Sour Music TV, it always take time with basically BIA. What I was saying is that if you have good reason, you can try to expedite your case with BIA. Okay, just Google BIA expedite request. It gives you exactly what to do. Okay, um, that's what exactly you have to do. If you're tired of waiting, you can try expedite request with BIA. And we talked about it in my last time when I was talking about adjustment of status. One of the video has that. Pretty much, I was telling people how to go about it. Okay. They charge the person saying being a U.S. Did the person say that, or did the person say that she Wilbur Valestiel, okay? People enter with false document or U.S. citizenship because they're running away in their country. They use somebody's document because they're running away. If that person came and they were trying to apply for asylum, there is an argument for it, okay? But if the person himself is say that yes, I'm a U.S. citizen, then of course they're gonna charge. But when they charge you like that, then you have to defend yourself and say, no, no, no. I'm not a U.S. citizen. I was just using the passport so I can run away from my country. That's why people apply for asylum in those type of circumstances so that they can match whatever they're saying with the under those circumstances, so to speak. You know. So my question is: did the person apply for asylum? Did the person defend themselves? What happened? I have a lot of questions. That's why that person need a consultation. This is not an easy matter, you know. Oh, Grace Dam, you have an individual hearing coming next year, June 2024. Good luck with that. And what is the question, Grace Dam? What is the question? Alessio, my brother has the visa. He can't go to school because of financial issues. So can he apply for asylum? Does it affect his? Well, Halia Sila, depending of yeah, it's gonna be difficult, right? A person comes here, didn't go to school because of financial issues. Now they're trying to apply for asylum. Depending on the story, right? Depending on whether the asylum in question is valid. Okay, if the asylum in question is valid, then yes, they can apply for asylum. Is it going to be difficult? Yes, they have to explain themselves. But I have a client who previously came as an F1 student and applied for asylum on his own and won. And now he's my client. We're trying to adjust status to get his green card. Okay. So the answer is yes. They can do it if they have a valid asylum claim. Sila, alias Sila, you need, yeah, that F1 student visa, he needs a consultation, okay? Just forward this link. This is the link for consultation. Forward that to him. Yes, we got 20 people. Please go ahead and share. Please go ahead and like. And Gonzalez is making sure you like and you share, okay? Sawa Music TV. Thanks, Bijoux. You're welcome. Yeah, you just have to try expedite request. That's it. And see if BIA is gonna agree with your reasons. That's it. Because BIA can take up to 5 years just to respond to one thing. So, any more questions? We got 21 people. Any more questions? I'm here for the questions. And don't forget, we have this all week, okay? This entire week, we are going to talk about removal defense. We're going to give you strategies. I'm going to talk about old cases, how we were able to win it, asylum case, of course, how we were able to win it, um, and so forth. Okay, Grace Dime has a question. Please, what does internet-based individual hearing mean? Oh, Grace Dime, it simply means that your hearing is gonna be online. Like they're gonna give you like the way you're seeing me like this, they're gonna give you a link, then you're gonna click on the link and get in the online. Like you don't have to go to physically go to court. That's what it means, okay? It's gonna be via like this, like on a camera. You're at your house or at your lawyer's office on the computer, so you don't have to go physically to court. Okay, that's what it means, online. Yeah, Lindsay Doro, what I was saying is that they burn your house. Do you have proof? The gangs did this. Do you have proof? So if you have all those proof, you come up with those proof and you file your expedite request. It is a valid reason. It's just, but as far as is it going to be approved, I cannot tell you that because I don't know. But the question was, is it a valid reason? Yes, it's a valid reason to try to expedite the case because of country conditions and the person who stayed there is in danger. Lindsay Door, did you get it? My Eva, sir, the problem is he can't get any proof because oh, they don't have any proof. Yeah, you can explain my Eva Cyrus. You can explain all that. They don't have proof. You can explain it and say that the police said that they don't have proof. Explain all that. Country conditions are dangerous. Uh, I mean, things when it happens, sometimes is you can find it in the newspaper, right? So if you find the newspaper, then you can try to get those newspaper and try to get those newspaper and try to show that as proof. If you don't have it, just explain it and see how it goes. I mean, filing for expedite request is free. You're not really losing anything, you know. You always have to try. I always tell my client, you have to try. Even if it gets denied the first time, you can wait for 3 months and try again with different set of facts, right? As long as those facts are correct. Sour Music TV, your cousin need to file a lawsuit. Waiting for asylum. Yeah, just if it's taking too long and you need an answer, you just file a lawsuit. That's the only solution. I mean, you can try expedite request. If it doesn't work, yeah, you file a lawsuit, then it's going to work. 7 years, oh yeah, it's gonna work. I do. By the way, Sour Music TV, tell your cousin I do mandamus lawsuit. We're gonna file it here in Maryland because the headquarters are here in Maryland. USCIS is here in Maryland. So yeah, just tell your cousin to schedule a consultation so we can file a lawsuit if he needs the answer. As far as asylum pending with USCIS is concerned, 7 years is too long to wait. I mean, if he doesn't want to wait anymore, he can file a lawsuit, okay? That's the only solution that actually works. 22 people, please go ahead. Please go ahead and share. Please go ahead and share. Yes, I'm waiting for other questions. Music TV, Sour Music TV. Last time we were here for adjustment of status, I didn't see you. What happened? You missed all our sessions. And by the way, bring your cousin tomorrow because tomorrow we have another live session. We're going to talk about some fraud. Since we're talking about fraud, we're going to talk about fraud, and marriage fraud and removal, and fraud like using a false document to enter the United States. The thing that Wilbur Valles still were talking about, that's what we're going to talk about tomorrow. Then I'm going to show you how it works. It actually works. Okay, tomorrow. That's what we're going to talk about tomorrow. I'm going to show you some case laws that we use actually. So transferring my case is pending immigration court, New Jersey. I got a master hearing, but I want to transfer my case to Chicago immigration court. Oh, because you live in Chicago. Yes, you can transfer it in Chicago because you have valid reason. You live there, you can transfer it. You just show your lease agreement as proof and your job as proof. You can transfer it. Is it going to affect the hearing? Yes, it can push the hearing forward or it can push it backward. It just depends on their availability in Chicago. But 2026 is far away. I don't think it's going to go beyond 2026. It might come before 2026, but I don't think it's going to go all the way to 2027 just because you move it now. I don't think so. So, but as far as transferring the case, you have valid reason because you live there, you work there. As long as you can prove it with proof, they're gonna transfer it. That's the like actually the lowest standard, you see. Can you handle? Tanimu Osman, can you handle a case in a different state? Yes, it depends. What type of case? Are you in removal or are you just dealing with USCIS? Um, if you are in removal and we actually have to defend it there, but nowadays, they're doing web, internet type of hearing. It doesn't really matter. So I can, yes, the answer is yes, I can handle cases. Okay. And Tanimu Osman, last time I asked you to do a consultation, you never did. What happened? But the answer is yes, I can. Lewis Gat. Hello, Miss Bijoux. Yes, hello. How are you, Lewis? Where are you located, Lewis? Oh, ok, merci, de rien. Sour Music TV. Lindsay Door, can someone expedite? You can always try the expedite request. It's just a matter, is it going to get approved or not? But as far as expedite is concerned, you can try. It doesn't hurt your case. You're not losing anything by doing it. The answer is yes, you can try. Augustine Akinewa. First of all, if you have a vow pending and you got remarried, wow. This is, we usually don't suggest that a person who's waiting for VAWA to get remarried. Okay? Because automatically the VAWA case no longer has too much weight on it. That's why we really don't do it. Why did you do it? Because now what you're going to have to do is just withdraw your VAWA and then go with marriage. I mean, even if you leave VAWA there, you go for marriage, you just complicated the entire situation. Why would you do that, Augustine Akiniwa? We usually, when I have my clients and all lawyers, when they have somebody has a VAWA case, we always tell them just wait until the completion of your VAWA before you get married. Otherwise, you're defeating the entire purpose of filing for VAWA. So, and that's might cause denial, and they might even doubt your second marriage. You see, why would you do that? Augustine Akinewa, you need a consultation because I need to give you some personal advice. Let me put the link for the consultation. You need a consultation because you need personal advice. Yeah, because you live in a different state. But if we are filing, like, let's say we're filing a motion to terminate, or we're filing like reopen to terminate your case, prosecutorial discretion, it doesn't matter where you live. If you're dealing with USCIS, we need to file some paperwork. It doesn't matter where you live. So that's why I'm asking what type of cases. I can't remember what we talked about yesterday, but yeah, that's what I'm asking. What type of case do you have? Gonzalez, yes, we're going up. Please like, please share. Sour Music TV, you need to watch my video, okay? And you need to Google EOR expedite request. It gives you the reasons. I'm not gonna repeat the same thing I already said. You need to go on EOR expedite request. Let me put the link here so you can go Google it, okay? Okay, Sawa Music TV. I just put the link for EOR expedite request. It gives you all the reason why there. Lewis Gate, Virginia. Lewis Gate, you just right here in Virginia. Do you need a lawyer? I mean, if you need an immigration lawyer, I'm here in DC. So, and you're in Virginia. So you need somebody in this proximity, okay? I mean, if you don't have one, of course. Um, I guess this is it. 45 minutes of talking. My friend, thank you for coming. I'm really happy that you came. Okay. Thank you for coming. Thank you for liking. Thank you for sharing. I want to see some of you bringing your friends to more sour music. You need to bring your friends to more so we can talk about what's going on with his case, and then we for a lawsuit. Tanimu Osman, you need to schedule your consultation. Augustine Akiniwa, you need to schedule a consultation. Lindsay, yes, you can expedite your request. Alia Sila, you need to bring your friend tomorrow, so we'll see if we can answer his question or if he needs a consultation. So this is it, right? 45 minutes of talking, my friend. It has been a pleasure. Happy Labor Day. This was great. I like today. I like this type of interaction. Tomorrow, we are going to talk about fraud and removal proceedings. What type of waivers, entry, with forging a document, what's going on. We're going to talk about it tomorrow. Yeah, Tanisu Osman. This subject we already talked about. Yeah, we will. You can. You have to have a good cause if you want to push your case closer. You have to have a good cause. Okay. It's if you're in immigration courts, it's called motion to advance. Okay, you need to file a motion to advance hearing and provide good cause. Good cause / reasons. Okay. Wilber Valestil, thank you. Yeah, so this is it. Okay. Thank you for coming. Thank you for sharing. Thank you for liking. I'll be here tomorrow, sometime 6 p.m. Eastern Time. We are talking about removal defense. That's my favorite subject. That's where I'm the most comfortable, okay, with immigration court. So we're gonna talk about that's when I know my stuff, okay? So we're gonna talk about fraud, the type of waivers available in removal as far as fraud is concerned. Specifically, we're gonna talk about those forging marriages too, um, the standards and stuff like that, okay? I'll see you tomorrow. Until next time, bye-bye.